Okay, are we good? Okay, are we ready to go with the seminar? Excellent. My name is Ken Vercammen. I'm an attorney in Edison, New Jersey, and I'm here to talk to millions of people in the world about 2025 wills, estates, estate planning, etc. So, believe it or not, in New Jersey, they reduced the taxes a couple years ago, and they did away with the New Jersey estate tax. Before that, every dollar over $675,000 that was going to a non-spouse, there was a very high tax. There is still a federal state tax, though, but in 2025, it only applies to people that with more than like $13,900,000. Not too many people have that much money. New Jersey also reduced the inheritance tax, where there's no tax that's going to spouse, children, grandchildren, step-children. After that, though, there isn't, and there's no tax that is going to any charities. There is a tax for brothers or sisters. The tax is at the first $25,000 is tax-free. After that, it's a tax at 11%. But to every other human being, it's taxed at 15%. Some people said, "Oh, it's a shame that the tax is so high." It goes, well, you have an option. You can just disclaim to get nothing. It's better to get something. Now, talking about the New Jersey estates, when you're preparing the will, I mentioned that there's no tax that is due for charities. And we love taking care of charities, but it is best to give set amounts to charities. If you're giving percentages to charities, that means that the Attorney General's office not only has to be notified, but they have to approve your accounting at the end of the case. It sometimes takes them a year to review it, and they could require a formal accounting, which the accountant might charge you $10,000. So you're thinking, oh, I'd like to leave 1% or 2% to St. Francis Grammar School or to St. Thomas High School. You're better off saying, I'm going to give them a set, $10,000, $20,000, as long as my estate is more than X amount of money, because the executor doesn't need more work. There's, I saw a client today that her brother did a will and was leaving, a 1% or 2% to different charities, and that meant that took 3 years to resolve between the Trenton people resolving. Now, sometimes people say, why do I need to have a will? Some people say, I'm married, doesn't everything go to my kids? Yes, but it goes to spouse, and then if it's children, the same relationship to the children. But even if there's 3 kids, that means they all have to agree upon who's going to be the administrator. And if there's no will, and all the people who aren't going to be the administrator have to sign this thing called a renunciation form, and have to sign in front of a notary and pay a fee. But sometimes you get someone who's a pain in the behind and says, I'm not going to sign that. That means that there has to be a formal complaint, order show cause in a superior court, and a hearing in front of a judge, and everyone on the plaintiff that would have inherited, they have to be put on notice. So, there's an expression, don't cheap out. Get your stuff done. And also the surrogate says, don't use those cheap or free online forms, because they see, unless you're with the surrogate's office, their problems usually are when people do that, and it's kind of like doing your own electrical work. Yeah, if you do it right, you did okay, you save money, but most of the time you'll do it wrong and you burn your house down. I'm going to watch a YouTube video on doing plumbing work. If you do it right, you save money, but most people will do something wrong, and then they have like water and sewage coming from the 2nd floor to the 3rd floor. They still got to hire a plumber. Also, if there's no will, or the will wasn't signed, properly, then you got to go through this administration process. And but the most important thing is, when someone has passed away and people are mourning, they should have one more thing to think about. Doing a will now has become much, much easier. The old system used to be, have someone take off of work, make an appointment, and come into the office and write down their stuff on a piece of paper. Then we went to the form where they could fill out by hand. And half the time I couldn't read the people's handwriting anyway, or the spelling of their, their kid's name or their spouse names. Now, it's easy enough. We email them a short questionnaire. What's your name? And who's going to be executor one, who's to be executor two. You don't want to have joint executors because that means that two people got to go to the circuit's office and qualify. Two people got to sign every check and every single thing. It's not that complicated when they're twins living together, but when they don't live in, and sometimes you get people who don't agree. We were involved with a case where there was two brothers. The father made them joint executors. They couldn't agree upon what color the sky was. Brother number one says the sky's blue. The other one says, no, it's gray. You're stupid. You've always been stupid. The judge eventually said, fellas, why don't you guys go out and have a cup of coffee and talk about the fun stuff you did as kids? I mean, you're spending more money on court costs and fees than the stuff you're fighting about. So you want to have an executor one and executor two, not joint. Some people say, oh, I'm not good at typing. I'm not good with the internet. Somebody saying, hey, no problem. Listen, let's say you can have a family member or friend type it up for you. And then sometimes we'll say to someone that goes, okay, do you got any grandkids over 17 that don't live far away? Oh, my granddaughter lives like 2 towns over. Okay, call up your granddaughter and say, listen, I need your help filling out this form. Can you come over the next 2 weeks and I'll give you $5,000 to do it. If the grandkid says, no, I'm too busy to visit you for the next 3 weeks, no problem. I won't leave you anything, I'll take you out. So that usually, brings people in. Since they eliminated the New Jersey estate tax, I don't need to know a lot of details about people's assets. Some people said, you'll call them up, oh, you haven't typed up the questionnaire. Oh, I'm trying to get together all my assets. He goes, I don't need to know your assets. It says, what real estate do you own in New Jersey? What real estate do you own somewhere else? And what's a ballpark of everything? I mean, I don't need to know any assets, or certainly not account numbers. And then they're going to list, hey, who gets your stuff? Easy enough. And then it goes down. If that person passes, who would get that? People are not so you can leave your assets to wherever you want. If you want to leave everything to the Yellow Dog Society, hey, that's right. The only thing you can't do is leave your spouse penniless. But kids or grandkids have no right to inherit. You don't have to treat people equal. Last year, a client said, do I have to treat all my kids equally? He goes, nah, what's your concern? She goes, oh, well, one of my kids, I don't hear much. He lives on the West Coast. I don't hear much from him. I go, okay. Well, did you get a card or a call on Christmas, your birthday, or Mother's Day? No. He goes, why would you leave anything to that bum? Wait, he doesn't call you on Christmas? And he goes, let's see. I was involved with an estate where, the father first wrote out the daughter because there was always arguments, and then he goes, hey, I'm doing a new will. I'm not going to leave anything to my grandkids. They haven't seen me, had anything to do with me for the past 2 years. They're both in their 20s. They live the next town over. And then when he passed, the daughter's like, oh, I wish someone would have told me that he was, he had cancer. I goes, well, yeah, I wanted to say, you should have, you live 2 towns over. I go to visit my dad every 2 weeks. He's 90-something years old, but it's not because I'm expecting a windfall, because that's what people should be doing. So it's your right to do with your stuff what you want. Sometimes, though, people don't leave money to their kids equally. Some might need it more than another. A lady, she goes, I got 3 kids. I love them all equally. I'm not doing preferences, but daughter number 1 is married to Dr. Rosenberg, the plastic surgeon. Their house in LBI on the water is worth $5 million. She doesn't need, a piece of my estate. She would go out and buy a piece of jewelry. My other daughter did okay. My 3rd daughter married the bum. She don't, he didn't pay. They got divorced. He don't pay child support. He don't pay out. She needs it more than the other ones. On the other hand, sometimes people say, My one, people that have special needs kids are smart enough to say, listen, I need to set up a special needs trust. But your concern is sometimes you get, a kid or a grandkid that's like, has problems. They're alcoholics, they're drug people. They just would spend the money within a week. So people can set up what's called a testamentary trust, and they don't get the money, and someone holds off the money for them. And so logistically, I was involved with a state where, lady sets up, has 4 kids, everyone gets, 20, a fourth, but the one for the son that was an alcoholic, it was a testamentary trust. The money's held for his benefit, and the oldest daughter was the trustee, and she could pay her brother's apartment, rental, pay for his car insurance, buy him ShopRite gift cards so he could buy food for meals rather than like buying booze. And so the guy's ex-wife, in that case, brought an action in Superior Court to compel the court to require that the trust pay her undue alimony. And I said, Judge, that's the reason why we set this up. Here's the case law that the prior cases that say it's protected from it's like an irrevocable trust. It can't be attached by Medicaid. It can't be attached by taxes. If they say I owed $1 million in taxes and the IRS said pay us the money, well, you could say, good luck to you. You ain't getting anything. So that's, so it's, we go over this with people. And now some people have what's called specific bequests. So sometimes the ladies will say, I want my jewelry to go to my daughter, my granddaughter, because the guys will bring it to Cash for Gold. And he goes, hey, what do you give me for this junk? Sometimes the guys are sportsmen, and they're like, they have like, hunting stuff that you got to be licensed, or they just wanted to go to someone that has it. I do tell people, I goes, listen, it's special stuff or valuable stuff that someone might want. Nobody nowadays wants someone's china, even if it was your grandmother's china, because people don't use it. You can't put it in the dishwasher. Got to wash it by hand. Who wants to spend Thanksgiving night hand washing stuff? Nobody. Some people have specific requests of money to a church, a charity, whatever. It should be specific. Don't just say my church, St. Francis, or because you should always have a clause. Make it specific. A lot of the charities have on their website how it should be titled, and then a clause should say if this charity ceases to exist or merges with a different one, where that money would go. Don't leave something dangling where the family has to spend money before a Superior Court judge. And we also we set up testamentary trusts where if the kids are under 18, they get some when they're 21, some when they're 25, the balance when they're 30. But the person who's the trustee, it's usually the same person as executor, can save as much money as is needed for health, education, maintenance, support. Some of the older people, I say, listen, instead of giving it to your kids that are grown, have their own house, why don't you give it to your grandkids to be used towards college? Because most people never saved enough money to pay for college, and I don't know, how much is the tuition for UMass per year?
Like 45.
45. Okay. How many parents have saved? Okay, I already put aside $200,000 for tuition plus zero. Now, some years ago, I went to University of Scranton. I love Scranton. I was a runner in Division III, and I would say, I'm going to give $2,000 to Scranton this year. My wife goes, my kids were younger, how much have you put away for your own kids? Nothing. You're going to leave $2,000 to total strangers, and you haven't put away, a nickel for your own kids? Well, since you said that, I guess Scranton's not getting $2,000 this year. Now, we John, all the wills we have a clause, no one under 21 gets money, but it gets held, but can be used for health, education, maintenance. And it kind of encourages someone, say, listen, I might as well, because if someone who's 19 gets money outright, and I discuss this with clients, he goes, listen, let's say your kid could be almost the valedictorian of their school, but if you and your spouse aren't around to help them out, they're going to be influenced by whoever their girlfriend is at the time to say, oh, you haven't bought me any jewelry, you must not like me anymore. Their friends are going to say, wow, you got 200 grand. You should go to Maloof and buy a sports car, and then we can have a house down in Seaside for the summer. This is great. All this money's sitting around going away. So you need to protect people from their friends. I had a guy that was on my high school track team that his mother had passed away and his brother was killed by, and the guy never had a will. That meant that one of his surviving sons got all his $75,000 in 1978 money. He went through it all by the time he was 21. Drugs, parties, etc. So the whole part of planning is doing it right. Only not that complicated doing it. Let's say for the people that don't have minor children, we even have a one-page form that says, okay, those couple things. I don't need to know a lot of details, but only the original will can be admitted to probate. Make sure that it's in a place where people can get to it. Don't be a putter-offer. Don't be like Carl. What's a Carl? Carl was this guy that he was a retired engineer and came into our office, and it was when they still had the estate tax, but I said, listen, I can set it up where there's no estate tax at all. Some goes to your wife, some in a testamentary trust for your wife. And he goes, I want to read up on this. You know how these like old engineers are? They were the kind of people that, read through whatever product they buy. They would read through the whole manual. They buy a new car, they got a car and they read through the manual. I said, Carl, you don't need to read anything. I went to law school, I passed the bar, I lectured for the bar, I wrote a book on this. When I had knee surgery, I don't read anything about how the doctor was going to do knee surgery. I don't want to know. He goes, hey, doctor, you've done this before? He goes, Kenny, I could almost do this in my sleep, but the medical board frowns upon that. Okay. Carl, I want to read up on it. 2 years later, the office gets a call. Hi, this is Carl's daughter. He passed away. Do we have his will? He goes, no. He kept on wanting to read up on it, and he put it off. So don't be a Carl. There are certain assets though that you don't need to read anything. Go to an attorney that does this all the time. If someone called me up and goes, oh listen, I need someone to handle my landlord-tenant case or Social Security, I don't do it. What am I doing mostly now? Wills, probates, and estates. Now there are certain assets that don't pass under the will because they already have direct beneficiaries. So, for example, if a house is owned husband and wife, automatically goes to the survivor. The will can't change that. If someone has bank accounts that are payable upon death, joint tenancy, POD, automatically goes to the survivor. And on the other hand, some people, if they do the will, say, listen, you want to get printouts, old-fashioned printouts, so you can put it with the will so that it's clear to you. Don't assume. We were involved with a state where the daughter saw her father fill out beneficiary forms and saw him put it in the mail. Well, the company never got it. It's not that, even if they made copies, it's a company has to get it and change it so it's clear what people want. Okay, let's talk briefly about trust. Let's start with what's called a revocable trust. Again, we get a call once a week. Oh, I want to set up a revocable trust. And hey, one time my mother-in-law, she used to call me every other year. I want to come in and get a trust done. I go, were you watching Susie Orman on TV? She says, oh yes. And I go, Susie Orman is right if you live in New York, California, Florida, where the probate process is very complicated. New Jersey, super easy. All the surrogate needs is the will. Original will, death certificate, check for $190 or so, and then they send you the letters testamentary. And it goes, hey, good luck to you. Do the right thing. Try to get advice from an attorney somewhere. So not that if you have a valid will, not that complicated. So when people say, I want to get a trust done, I go, why do you think you need to spend between $3,000 and $6,000 setting up a revocable trust? Other than Susie Orman, who sells trusts for New York people, says you should have one. It doesn't cut down on taxes. Some people go, I want to avoid probate. Probate, as long as you have a will, is not that complicated. It doesn't protect assets from Medicaid. So I go, okay, listen, I love making money. Someone says, I want to have a revocable trust. After we explain that to them, okay, fine. It's all the stuff is on our website, njlaws.com. If you type in a word or a clause, there'll be an article or some information on it. There's a different kind of trust called a Medicaid or irrevocable trust. But that means that you're not only are you not owning the assets anymore, you can't be the primary trustee, and you can never change it. And if you set this up, and for the purpose of Medicaid, you can't go. You can't apply for Medicaid or go to a nursing home for 5 years. What if there's a falling out between you and your kid? And he goes, what? Never mind. Let me have it back. Hey, screw you, mom. You transferred it to us. You're out of luck. So. The attorneys that do these Medicaid irrevocable trusts usually charge between 12 and 15 grand. And they say that's the cost of 1 month of nursing home. If we can save you 1 month, you come out ahead. I've had clients say, well, sometimes it's not the client. Just daughter would bring in mom. Oh, my mom wants to protect her assets. I get to know. Mom don't care. It's the daughter wants to protect her inheritance. First they said, why don't you go and pay money for long-term care insurance for your mom? Oh, I don't want to spend my money. And then the daughter says to me, well, what would I do? I goes, you're asking me, what did I do? I goes, I'm not transferring all my assets to my kids or into an irrevocable trust where I have no control over it. So I go into the welfare nursing home. There's nice nursing homes and there's smelly nursing homes. Let's see. I want to go to the most expensive nursing home. If I'm that sick that I can't get up out of my chair and wash myself I don't want to go for those last weeks and months. Hey, I want to be where I'm comfortable. I want the one where I got my own room and they put a piece of chocolate on my pillow like at the Hyatt. Not the crappy one that smells of like, pee and vomit. Okay, so, many people through their employer have what's called a legal plan. So, in New Jersey, some of the biggest three are the MetLife legal plan, ARAG legal plan, and Legalese. Some of the retired auto workers for Ford and General Motors have that. Quickly, because I'm running out of time, we're going to talk about what's called a power of attorney. A will takes care of your assets if you pass away. What a power of attorney is you're giving the power while you are alive to someone that can help you out legally. Let's see. So we recommend that it be what's called a durable power of attorney that's effective right away and stays durable even if you become disabled. A springing power of attorney only springs into effect if you become disabled. So we had a client, Fred. Fred goes, Kenny, I don't understand legal stuff. I'm a carpenter. I only know hammers and tools. Explain to me in carpenter language this power of attorney thing. I goes, okay. You put your son as your executor or agent. Yes, okay. Well, if the power of attorney is effective right away, he can steal all your money right away and go to Cuba where it's warm. If it's effective only upon disability, he has to get a note from a doctor before he steals all your money and goes to Cuba. Knowing that, you trust your son. He goes, I trust my son with my life. Make it effective right away. Don't make it more work. Now, some of the banks, there was a change in the law because some of the banks were giving people a hard time. They said, it wasn't done in our form, and it has to be done in our bank's form. So New Jersey legislature came down with a statute that said if it made reference to the New Jersey statute, then the bank is in New Jersey, they're supposed to honor But that means that it has to make reference to this, Section 2 of PL 1991, C 46:2B-11, the statute. And that's why the surrogate, I warn people on using cheap stuff online, because if it doesn't make that, the bank can say, not valid in New Jersey, and we ain't gonna honor. We do recommend a power of attorney be signed every 5 years. A will is good forever. There's no statute in New Jersey that says how long a power of attorney is good for. So, how much extra work is it to have a new one prepared and signed? It got and so the power of attorney is signed by the person twice, and we have them sign it twice to make it effective right away, and then the attorney and notary sign. So, once a week we get a call. I need to get power of attorney over mom, dad, my brother. He goes, you can't get power of attorney over anyone. They have to affirmatively give it to you and sign the documents. We have some people hospitalized, sick, whatever. I goes, okay, can dad or mom, you can type up the form, but can they talk to me over the phone and tell me what that they want this? If the answer is yes, we try to work with people, and then they can bring a notary to the house. And it goes, but they say no, they had a stroke, whatever. He goes, well, then I can't do. Then they have to go through this expensive thing called the guardianship, which takes a couple months. Costs $3-4 grand. So the doing a $400 power of attorney is an investment. Let's say I had disability insurance for 38 years. Let's see. I never got disabled, never collected. I goes, I think that in a way that was my guarantee I wasn't going to get disabled, is by paying all this money for disability insurance. If you have a power of attorney, hey, maybe it's your guarantee that you never need it. But it's always good to be there, because again, when we get this call on Friday afternoon, oh, I need to do this, this, and this, can't do. The last document we're talking about is the Living Will Advance Directive. What the Living Will Advance Directive is you're giving instructions to hospitals and doctors saying, hey, listen, let's see, if I'm in a coma, irreversible condition, I want to be able to kind of control my future. Or really, it's like, I don't want to be on feeding tubes, life support, etc. If I can't get up, open up my eyes, and enjoy my life, really, what is the purpose of that? To not be able to enjoy it. And the power of attorney is not really for you as a sick person. It's really for your family, so your family doesn't have to suffer where they are having to make the decision. One time I got a call from a doctor, and it was a little lady that she her husband died, didn't have kids, her sisters died, and she had me on her power of attorney because she trusted me, and the monies were going to charities and friends, but she never wanted to do the living will. Yeah, she was against it. Okay, fine. Doctor goes, okay, listen, she's at X hospital. We don't think that she's going to last more than a week. Should we remove life support? I'm like, geez, doc, I feel bad. You know the right decision is for someone who's 92 years old. It's not going to open up their eyes again, but you hate to be the one to say, yeah, go ahead and do it. I'd say, yeah. So the whole idea is doing it ahead of time and saying, listen, if I can't get up and open up my eyes and enjoy my life, and I'm just going to be in pain, I don't want to be kept alive. So. If you don't already have these documents, contact a good attorney. Ken Vercammen's office phone number is 732-572-0500. And for the majority of the people, we don't even need to see them in our office. The only time people come in is if they don't to get things signed. But a lot of people, we set it up where they can go to their own notary. It just says sign here, sign here, sign here, sign here. Our website NJ Laws has more information on this, and but the most important thing again is get your stuff done. If everything is done and in place, it's good. The last thing I do mention is it's a good idea to scan your power of attorney and email it. In addition to emailing it to executor 1, executor 2, send a copy of it to your accountant and your financial advisor so that they know that if all of a sudden you can't call up, that you are good. And the living will, you should scan that or copy it and give a copy to your primary doctor and appropriate family member. Oh, and I will say the other thing with the living will is that sometimes you got one child that was the real helper in the family, okay, and there was one child that wasn't really the helper. Then all of a sudden, mom or dad, they're at their end, they're in a hospital, and that person that wasn't the helper, marches into the room and says, "Okay, I'm in charge now." And the answer is no, you ain't in charge, because back in 2005, mom did a living will and a power of attorney, and I'm in charge. And you're lucky we even let you into the room because you weren't around for the past 4 years when we needed your help to bring them around. And with that, everyone, have a great day. My name is Ken Vercammen. We're in Edison, but we do wills throughout the whole state of New Jersey. Thank you. Have a great day.